Good afternoon and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace and I'm presiding over this oral argument. I have joining me on the panel from our court, Judge Dan Traver and Judge Mary Nardella. And we have one case on the docket here at 1:30. It's the Lynn CG South LLC and Lennar Homes LLC versus Champions Club Condominium Association, Inc. And I would just ask that the parties, when you're not speaking, if you could keep your mics on mute. And also, if you are speaking, make sure that in the background you don't have something that's going to make some noise and interrupt your presentation. I will assume, Mr. Ali, that you prefer 5 minutes of rebuttal unless you tell me otherwise. We can adjust that on the fly here.
Actually, may I reserve 7 minutes for rebuttal?
Yes, sir.
Thank you.
And so other than that, Mr. Ali, you have the floor.
Thank you. Again, good afternoon, everyone. May it please the court. Adam Ali here on behalf of the appellants, Lennar Homes and Lynn CG. The issue on appeal, of course, is whether the association must submit its claims to arbitration. The trial court's contrary order is erroneous for many different reasons, all of which are addressed in the papers. In short, though, this court may and indeed should reverse that order solely by virtue of Section 36 of the Declaration of Condominium, which provides very clearly that whereas here the association pursues a construction matter, it must do so in arbitration. The same result, however, obtains even if we ignore Section 36 in its entirety, because the association pursues its claims on behalf of its individual members, the unit owners, all of whom, and I say again, all of whom are separately bound by arbitration provisions, including those in Section 26.1 of the Declaration and the original deeds for their respective units. Either way, arbitration is required. And I'll begin with Section 36 of the Declaration. In relevant part, it provides if any construction.
So before you start with that, just on the subject of the declaration, and I think you've already answered my questions, but I just want to make sure you're basically saying we can look at 36 and that's basically it. We don't have to look at 8.7 or 26.1.
Yes, Your Honor. This appeal may be resolved solely due to Section 36 of the Declaration.
And do you view 8.7 just as a basic notice provision that doesn't have anything to do with arbitration or a judicial action?
Yes, Section 8.7 requires, as the trial court noted, the association to follow Florida Statutes Chapter 558.
And do you view 26.1 as not mentioning the association at all?
I agree that the association is not mentioned specifically in 26.1, but it is bound by that section in two different respects. First, it's directly bound by way of Section 36, which says a party pursuing a construction matter, the association must arbitrate pursuant to Section 26. So it is directly bound by Section 26. In addition, Section 26 applies to all of the association's members. And because the association seeks relief on behalf of those members, it too must comply with Section 26.1.
But I understand that second argument to basically be a backup argument to the one that you started with, which is that we can look at 36 and 36 alone. And that while 26 might outline the procedure by which parties arbitrate, the substantive obligation comes from 36 and 36 alone, correct?
Correct. The court may and should resolve this based solely on Section 36, but Section 26 and the deeds provide further support for the proposition that the association must arbitrate.
Thanks. I just wanted to basically put a box around your declaration argument. Go ahead.
Sure. And the declaration says, again, Section 36, if a construction matter, which is what we're dealing with here, is not cured or corrected as aforesaid, meaning after notice and a chance to cure, all applicable parties shall be bound to submit the disputes or claims regarding the construction matters to binding arbitration as provided in Section 26. And here's the key part. Without limiting the general binding effect of this declaration, each owner shall be deemed to be fully bound by the provisions of this Section 36, as shall association. This could not be more clear. In fact, the trial court said as much. At the same time, though, the trial court concluded that Section 36 does not cover the association. This is in paragraph 15 of the trial court's order. Sections 26.1 and 36 are clear about the identity of persons required to arbitrate. That's true. Plaintiff is not one of those persons. Well, that's erroneous. That interpretation effectively rewrites and renders meaningless the last sentence of Section 36, which again states that the provisions of that section are fully binding on the association. That's contrary to Florida law. As this court said in 3 Keys versus Kennedy funding, when construing a contract, an interpretation giving a reasonable meaning to all provisions is preferred to one that renders part of the contract meaningless, and a court is not empowered to rewrite a clear and unambiguous provision. But that is precisely what the trial court did here. Even the association itself admits at page 22 of its answer brief that the last sentence of Section 36 means that it is bound by Section 36. Now, the association, of course, goes on to say that it's bound only by the portion of Section 36 requiring a notice and opportunity to cure. But that argument, just like the trial court's order, ignores the plain meaning, the plain language, that is, of Section 36, which again concludes each owner is fully bound, as is the association. It does not say the association is bound by some, but not all parts of Section 36. Fully bound means all provisions, including arbitration. Now, I'll talk briefly about Section 8.7 because the trial court cites it in the order and the association cites it in its briefs. The trial court's order at paragraph 7 says, 8.7 requires plaintiff to comply with Chapter 558, but notably, this section does not require plaintiff to arbitrate any of its claims. That conclusion also is erroneous. Section 8.7 requires compliance with Chapter 558. That is true. It does not, however, address at all the ultimate venue or forum for disputes, as do Sections 26 and 36, both of which require arbitration. Further, the association's duty to comply with Florida Statutes Chapter 558 in no way obviates its duty to arbitrate, because Chapter 558 does not require an action to be maintained in court. To the contrary, Florida Statutes Chapter 558 requires a claimant to serve a notice, and if the matter remains unresolved, it may commence an action, which is defined as a civil action or arbitration proceeding. This is in Florida Statutes Sections 558.002 and 3. The trial court therefore should have applied and construed Section 8.7 together with Sections 26 and 36, which is very easily done. If the association believes it has a construction defect claim or a construction matter, it serves a notice. If the dispute remains unresolved, it files a demand for arbitration. This is fully consistent with the procedure outlined in Section 36. But by relying solely on Section 8.7, the trial court once again rewrites or renders meaningless significant portions of this declaration, including those in Sections 26 and 36. This is reversible error. In Special Machinery versus Westfall, this court said, the meaning of a document is not to be gathered from any one phrase, but from a general view of the whole writing, with all of its parts being compared, used, and construed, each with reference to the others. The trial court violated this longstanding principle. And I say again then, arbitration is required by virtue of Section 36, and really no further analysis is required. There are, however, separate and independent bases for arbitration. As I mentioned, the association is pursuing its claims on behalf of its members. This is in paragraph 6 of its complaint. Accordingly, the association is separately bound by the arbitration provisions of those members, Section 26.1, the deeds. And this point cannot reasonably be disputed. The Second District confirmed it in 2013 in the Pulte versus Vermillion case, and the Third District applied that principle more recently in the Lennar Holmes versus Martinique matter. And that case is—
What do we make of the Hayslip decision from the Florida Supreme Court, which the trial court, in fairness, didn't have the benefit of when it issued this particular ruling? Is that particular ruling binding on us as an appellate body? And if so, why?
The Hayslip opinion is binding on this court. It's a decision of the Florida Supreme Court. The relevance, or the importance rather, of that decision is that the court confirmed that in fact the same form of deed at issue in this case, and this is what the court said: does a deed covenant requiring the arbitration of any dispute arising from a construction defect run with the land, such that it is binding upon a subsequent purchaser of the real estate who is not a party to the deed? We answer the rephrased certified question in the affirmative. All of the deeds for the units in this condominium include that same arbitration provision and state that it is binding not only on the original purchaser, but all others in the chain of title. The point is, all of the association's members are bound by the deed arbitration provisions. And so when we apply the analysis from Martinique and from Vermilion, so too is the association.
So I think basically what you're doing is you're taking the language in Vermilion and Martinique, which basically says that when an association purports to act on behalf of its members, that it can be bound. Even though I think your colleague would say that Mr. Hayslip was an individual plaintiff and not an association.
That is correct. The point from Hayslip is that the arbitration provision is a covenant that runs with the land and therefore binds all the members. And therefore, when an association seeks relief on behalf of those members, it too is bound. And this is true not only by virtue of the deeds, but by virtue of section 26.1 of the declaration, which also applies to all of the members of the association. And in Martinique, an association sued Lennar Homes, which is one of the appellants here. And the association pursued its claims on behalf of its members, which is what the association is doing here. The association alleged defects in common elements, which is what the association is doing here. Lennar filed a motion to compel arbitration based on, among other things, the same deeds we're dealing with here. The trial court denied the motion, the third district reversed. And here's what it said. Lennar contends that because the association is suing in its representative capacity on behalf of its members, and because those members each agreed to arbitrate their disputes with Lennar, the association is likewise bound by that provision to arbitrate. We agree. The association cannot avoid the arbitration agreement signed by its members if the association's members agreed to arbitrate disputes relating to construction defects. The association is likewise bound. Now, the trial court, and of course, the second district applied the same analysis in Vermilion. The trial court declined to apply that reasoning here, finding that not all homeowners or unit owners are subject to the same arbitration provision. Well, that's wrong, because if 100% participation is required, we have, again, two such provisions, section 26.1 and the deeds. Section 26.1 says, by acceptance of a deed to a unit, each owner specifically agrees that any dispute shall first be submitted to mediation, and if not settled during mediation, shall thereafter be submitted to binding arbitration. So by its plain terms, section 26.1 applies to all unit owners. The trial court said as much in its order. The association agrees. Section 26.1 applies to the unit owners. And again, by virtue of the Hayslip decision, we know the deed arbitration provisions likewise apply to all members. And because the association seeks relief for those members, on behalf of those members, it too must comply with both section 26.1 and the deed arbitration provisions. And again, arbitration still would be required by virtue of section 36 of the declaration, even if we didn't have deeds, if we didn't have section 26.1, if there were no Hayslip, if there were no Vermilion, and if there were no Martinique, arbitration is still required here. So again, the trial court erred in denying the appellant's motion to compel arbitration, and we ask respectfully that this court reverse that order, and I will save the balance of my time for rebuttal.
All right, Mr. Kiernan, you may proceed.
Thank you. Thank you to the panel. May it please the court, Scott Kiernan for Champions Club Condominium Association Incorporated. I think it's important to point out that no party may be forced to arbitrate without an intentional written agreement to arbitrate. And they don't have an agreement here to arbitrate between the
Mr. Kiernan, I'm sorry to do that. I'm sorry to do that thing where we jump in right away, right after you introduce yourself.
That's all right.
I'm just wondering if I can try to set the same box that I did with your colleague.
Sure.
First off, do you agree that 26 doesn't mention the association at all?
Absolutely.
And it seems like in your initial brief, or I'm sorry, your answer brief, you also acknowledge that 8.7 is just a notice provision that doesn't bear on arbitration or litigation.
Absolutely, Your Honor.
As it relates to section 36, which is what's left, do you concede that this is a construction matter, this particular case?
I concede that this case is a construction matter. Yes.
Okay, so it sounds to me like we're basically talking about, as it relates to the declaration language of our decision as a panel, we're looking at 36, and it seems like we're focusing on what the three words that end section 36 mean,
Yes.
as shall association. Do you agree with that?
Yes.
Can you tell me what as shall association means from your client's perspective?
Yes, Your Honor, I would love to. They added that on at the very end. I believe 36 would apply to if the association were to own a unit. Maybe it's a manager's unit. And then that unit would have to go through the arbitration process just like any other unit owner, because it refers back to 26. Maybe the association had a lien foreclosure and took title to a unit. And then they would be now a unit owner, where a unit owner has a written agreement to arbitrate with the developer. Then they would have to pursue in owning that unit how they would like to, how a unit owner would have to arbitrate pursuant to the association taking a lien foreclosure. I don't know what they meant by adding on those three words at the end, but it could not be more unclear and more ambiguous, and that should be construed against them. They don't even have a written agreement to arbitrate with the association. And that's the seminal standard, the bedrock standard in US v. Seifert on anyone wanting to compel arbitration. And for them to say, well, we have this, we're going to hodgepodge together three portions of the declaration to try to compel the association to do it, does not an arbitration agreement make. And
it's a little bit different, I think, than your argument in the answer brief, which is that those three words only apply to the notice provisions of 36 sub 1 and sub 2.
They could apply to that, but we don't know what they mean by 36. We don't know what they're talking about when they're talking about construction disputes. If they're talking about an owner's obligation for construction disputes, then if the association, as shall association, if they become an owner, then they would have to bring a construction dispute under that same term. That's the way I read it. But if it's ambiguous and it's construed against them, and if it's ambiguous, it cannot be enforceable to compel arbitration. So I don't know.
What if I changed the nouns and the context of this particular sentence and said something like, every player on the football field, along with every player who is on the sidelines, shall be bound to follow the rules of football, as shall the coaches.
Sure.
Under your interpretation, do the rules only apply to the coaches if they start playing the game?
That's a poorly worded provision. I would say under that provision, it would be difficult to compel the coaches, but under your analysis, I would be inclined to agree that that would likely include the coaches. But why wouldn't
what makes this paragraph, and I recognize, apologies for the awkwardness of it. It's not the greatest sentence I've ever put together. But if you acknowledge that in that context, the last four words, as shall the coaches,
right,
would effectively work to make them bound by the rules. Why do we read this last sentence as different than that?
Because this only means you're bound if you own a unit. This could easily mean that the association is bound to do this if they become title owner to a unit. Then once as a unit owner, rather than the fictional entity with separate rights that the legislature gave them, they would then have to follow the provisions that a unit owner would. By the way, they could have drafted this really easy. I've seen long legal page provisions and declarations that require an association to arbitrate, and they're very specific and they are in great detail. Why couldn't they just write the association agrees to arbitrate all disputes with the developer? I mean, that's
Mr. Kiernan. So the question that I have is, I follow what you're saying, but I believe the complaint that was filed by the association originally was a 10-count complaint seeking to bring an action, a class action, correct?
That's correct.
Okay, so the association was going to be representing the class, which would be the owners that decided to go with the association, was what, 168 individual owners?
Right, but the association doesn't need their approval to go forward with that.
Okay, but isn't that kind of a little gratuitous there? Because I mean, you're now making the argument that the association, if the individual owners would have brought the suit themselves or as a group, they would have been bound to arbitrate. But yet you're taking the position now that the association can sidestep that because they're representing the class. Is that correct?
That's correct. The association has their own independent ability to bring that claim under 718.
So none of those 168 homeowners that bought and purchased in the development are going to be bound by that arbitration clause. Is that correct?
No, the owners are, because the owners have a written agreement to arbitrate. If I answered your question. The owners have that written, I mean, that written agreement is critical. When the owner sits down at a table and agrees to buy in the community, they enter into a written agreement to arbitrate. I'll tell you why the Vermillion and Martinique cases are different. Those are homeowners cases. Those are not a condominium association where the condominium has a separate independent obligation to maintain the common elements, the buildings, the structure. A condominium has many statutory cause of action that they could bring, and they're the only entity there in the community that is required to maintain, repair, and replace the common elements. So Vermillion and Martinique are HOA cases where the owner actually owns the entire structure of that single family home, all the way to the end of the walls. In a condominium, the owner just owns that airspace from the paint in, their flooring, their cabinetry. If you were to take that condominium building and turn it upside down and shake it out, everything that falls out, those accessories, that's the owner's responsibility. That full structure itself, that is the condominiums association's responsibility. And that's a responsibility that they get by the legislature in 718. So the entire structure is a common element property that the association, they have a non-delegable duty to do this under the statute. Whereas in 1.221 in an HOA, if it's a matter of common interest, the association can certainly bring that claim like they did in Vermillion and Martinique. Under a condo, which is a completely separate fictional character created by the legislature, they can bring a matter that's not just not common interest, but a matter for maintaining the common element property, which they have the ability to do and the obligation to do. And under 718.111, no owner can act for the condominium association. So the association has a separate independent right. The division of condominiums even agrees with me. The division of condominiums even restricts these arbitration provisions in the declaration. So whether they weren't clear in 36 because they were trying to sidestep what the division of condominiums may say, or they just weren't clear in drafting the specific language requiring the association to arbitrate, I don't know what they were thinking, but they could have easily drafted it much better to compel the association, even despite my disagreement that the legislature says you can't. Well, even though I don't believe you can under the Condominium Act, you need to have a better written provision to do so, and you just don't have it. In Whittington Condo versus Bramer, it stood for the principle that the association has the capacity as an entity to bring suit in furtherance of its statutory duties, and the unit owner's obligation is not, they have no obligation to maintain these common elements. Century Village versus Wellington. We reject the argument that under the class action rule or 1.221, an association is identical to and standing in the place of the owner. The terms association and unit owner are not interchangeable under the statutory context of the Condominium Act. Association.
This would be the way, Mr. Kiernan, that you would try to distinguish Hayslip.
Well, on Hayslip, first of all, Hayslip is it's about a unit owner. And I would also say under Hayslip as well, that the deeds for the association here do not say anything about association claims. And they don't say that the association is bound to arbitrate. Those aren't in the deeds. So it's the Hayslip says whatever's in the deed controls. Well, that's not in the deed for these unit owners. And Vermillion even states, the Vermillion case, which is so heavily relied upon, states in there, we do not believe an association should be compelled to arbitrate a claim that is actually the association's claim in its own right. And this is what the association never waived its constitutional right to a jury trial. I mean, the unit owner did, they certainly did, but the association never made any such representation or never intentionally entered into any written agreement to do so. By the way, 36, that was never in the motion to compel arbitration filed by appellant. Now it's up for debate on this appeal, but it was never in the motion to compel. But 36 just leads you back to 26, which on its face is a provision with the owner and the developer. Nowhere in 26 is the association mentioned as an applicable party. And so again, 36, by adding those 3 words at the end, we're not sure if they're trying to say, okay, if the association was a unit owner and owned a unit by lien foreclosure, then it would have the ability, then it would have to follow this arbitration procedure. But it's ambiguous, and if it's ambiguous, it's construed against them. Actually, if it's ambiguous, the case law under Sefco v. Odom says you can't enforce arbitration. There's got to be a really strong written, valid intent to arbitrate here. So they just threw on, we think they threw on the association at the end, maybe to try to get them in to avoid the division of condominiums, or they just weren't real clear on drafting, but for whatever reason, it's just not clear. And if it's not clear, then they obviously intended to leave terms out for whatever reason, but it's not clear to compel arbitration. I mean, we may never know what is meant by 36 or how it's to be applied, but it's certainly not clear that the association is bound to arbitrate claims for common elements, buildings, condominium property. Those, if you wanted to write that in there, it should have been more clear. And while it may be to them, insurmountable problem that they have, this is a problem that they've created with their own drafting of this declaration. Association, by the way, on Hayslip, the association never signed a deed. They never ratified these deeds of owners. They're never the buyer. They're not the buyer's representative. They're not the grantee. The deeds themselves are actually between the owner and the association. I'm sorry, between the owner and the developer. Excuse me. That's a very important distinction. Even if the deed itself, the association claims do not meet, even in the language of the deed itself, the association claims do not meet the definition of a dispute in the deed. So Hayslip's different. If the deeds, as the deeds for the owners in the association here do not say association, and Hayslip's not an association case, and they certainly don't say the association is bound to arbitrate, and nor do the deeds cover association claims in the deeds here. Now they do say community, but that's an undefined term. And they don't say buildings, they don't say common elements, and they don't say condominium property. And actually, they just say the legal description is defined as the unit. Okay, well, if we're going back to that, then that's just the airspace. That's between the paint on the wall, between the paint on the other wall, and the cabinetry and the couch that you have in that condominium. That's what the unit owner is responsible for. So just that airspace is all they're talking about in the deed. And we're not stepping into the shoes of the individual owners. We have no absolute, we have an absolute duty to maintain the structure. And that's the distinction in an HOA. And that's a really important distinction. So the appellant could have argued that the association may have been bound by an arbitration provision, even though I don't believe it's proper. They could have put better language in there to make the association bound. But this language just doesn't cut it, even if you try to hodgepodge together 8.7, 26, and 36.
I mean, I think I think Mr. Elahi conceded that he's not doing that. I mean, I think that you guys are both on the exact same
Sure.
page. You look at 36 and 36 alone.
And if I'm looking at 36 alone, I believe they're talking about if the association becomes a unit owner, which is very frequent, happens all the time.
It seems to me that the placement of as shall association in this clause matters
Right.
as to where it goes. Your point, I think, is that if you moved to, well, let me ask it this way. Would your argument be stronger if I moved as shall association until after other person in that last sentence? So it would say each owner and other person, let's say, including the association, as opposed to as shall the association, blah, 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 blah. it seemed to me that that would be a stronger argument for what you're suggesting. I'm not saying you're wrong. I'm just asking you to agree with me if that would be a stronger phrasing.
That might have been a stronger phrasing, yeah.
So in my mind, our construction on 36 turns on where the import of where those last three words are and whether those last three words modify the clause that immediately come before it, the sentence that immediately comes before it, the whole paragraph that comes before it. Your reaction to that?
I think you have to read 36 in its whole, in its entirety. And it says, without limiting the general binding effect of this declaration, each owner and other person acquiring any right, title, or interest to a unit, and they're talking about an owner and an owner's unit, shall be deemed by virtue of acceptance of the conveyance, grant, transfer, or assignment thereof to be bound by the provisions of 36, as shall association. So association would be bound if it then became an owner acquiring a right, title, or interest in a unit. This didn't happen. The association never accepted a conveyance like that. So 36.
Are you abandoning the 36(1) and sub 2 argument, or are you just espousing this as an alternative basis or an alternative construction?
This is an alternative construction, but not. I tell you, on 1 and 2, it's not even clear there that the association is bound by this arbitration. The arbitration section is bound by the what I just read. That is where it's bound. That's where it binds the arbitration. And it talks about a unit.
In your brief, you say that your construction of this provision is that the association is only bound by the notice provisions of 36(1) and 2.
Right.
And it seems to me that if you do that, you're moving as shall association to a different place in the paragraph as well. So I guess I'm asking, are you abandoning that construction that you have in the answer brief and relying on the one that you're going with on oral argument? Or are you saying that both of them are true and you're not sure?
I'm relying on I'm not abandoning the argument. I'm relying on what our brief says.
What support would you give for as shall association modifying only 36 sub 1 and sub 2?
I don't have to make that analysis. Respectfully, it's up to them to prove that binds the association to arbitration of construction defect disputes as defined in the Condominium Act. The onus is on them. If they want to compel arbitration, the onus is on them to make it crystal clear. It's not on us. And it doesn't do that in section 36, which, by the way, section 36 was never argued as their basis for a motion to compel arbitration. So I understand what you're saying, but I think what we're trying to do here is we're trying to shoehorn the association into their construction defect rights that are given by statute into 36. And I just don't think we can do that. So for those reasons, that's why I would affirm the trial court's decision.
Thank you, Mr. Kernan.
Thank
Mr.
you.
Ali.
Thank you. Section 36 was argued, and we know that because it appears throughout the trial court's order. As shall association is very clear. And what's telling is that each time the association attempts to explain what it means, it either adds words or moves the phrase. It should be applied according to its plain meaning, which is clear. And by the way, if that meant that it only means as shall the association, if it's a unit owner, it's superfluous, because in the same sentence, it says each owner is bound. So it means what it says. The association is fully bound by section 36. The association itself says so in its answer brief. The association is left to suggest there's no agreement to arbitrate signed by the association. That's a rather remarkable argument. Florida statute 718.111(2). The powers and duties of the association include, among other things, those set forth in the declaration. Florida statute section 718.303. Association is governed by and must comply with the provisions of, among other things, the declaration. And cases often refer to the declaration as the association's constitution. So any suggestion that the association is not bound by the declaration simply is not credible. And I would say this too, in both Martinique and Vermilion, there were no agreements between the association and the builder. The courts both said the association had to comply with the agreements of its members because it sought relief on behalf of those members. The association attempts to distinguish those cases by saying, well, they involved homeowners associations. This is a condominium association. It's a distinction without a difference. In each case, the plaintiff association pursued relief pursuant to Florida Rule of Civil Procedure 1.221. That rule, by its express terms, applies equally to condominium and homeowners associations. The precedential value of those cases does not, in any respect, turn on the type of association at issue. The principle controls. Where an association seeks relief for its members, it is bound by the arbitration agreements of those members. The association also says, well, this case is a bit different because it involves common elements. It does involve claims to common elements. The owners, therefore, are the real parties in interest, just like the owners in Vermilion, just like the owners in Martinique. Declaration, Section 2. Unit owner means the record title owner of legal title to a condominium parcel, which means a unit together with the undivided share in the common elements. Declaration, Section 3.2. The aggregate of the existing unit owners in the condominium will at all times have 100% ownership in all of the common elements. Florida statutes, Section 718.103, 12, and 28 say the same thing. The unit owners own the common elements and are therefore the real parties in interest. Now, the association says, well, we have duty to maintain those common elements. It does. The costs of that maintenance and those repairs, however, are passed on to the unit owners as common expenses. And we know as a matter of law, a duty to maintain something does not eliminate the association's duty to comply with the arbitration provisions of its members. As the 3rd District said in Martinique, even if the association has an obligation to maintain some aspect of the property and can therefore bring suit in its representative capacity, it is nevertheless the homeowners who are the real parties in interest. So there is no difference between this case and Martinique, or between this case and Vermilion, and the same result should obtain. Again, though, Section 36 by its plain terms requires arbitration as well. Either way you slice it, arbitration is required, and nothing the association has asserted either here today or in its briefs leads to a different conclusion. We would therefore respectfully request, again, that this court reverse the trial court's order. And unless there are any additional questions, I thank the court for its time and consideration of this case.
I don't hear any other questions. Counsel, thank you very much for your arguments. It was a well-argued case.
Thank you.
And we wish you all a good day.
Thank you.
Thank you.